Welcome, America. It's good to have you back today. You know what? It feels like a Friday to me. Doesn't it to you, Mr. Producer? Or a Monday. And, of course, Mondays and Fridays have nothing to do with each other. But that's neither here nor there. I want to talk about the judiciary. I want to really lay into this because we actually have some libertarians and, unfortunately, some conservatives who have the mindset that what this court did, this United States Court on Trade in New York, which is a legitimate court, it's a federal court, it's created by Congress, it has 9 members, I looked into it, they're appointed for life. Life, I don't know why they're appointed for life on that court, but they are. But they have a tremendous amount of authority. But the president gets his authority from the Constitution. They do not. This goes to the heart of the matter. This goes to the heart of the matter that we've been talking about with the judiciary, my new book on power, goes to the heart of the matter. Who has the final say if there's a dispute? Now, we've been brainwashed to believe, every law student is brainwashed to believe, and hence virtually every lawyer, whether they're TV lawyers or practicing lawyers or whatever kind of lawyers they are, has been taught to believe that the court has the final say. And the Supreme Court has the final of all final sayings. That's not what your Constitution says. In fact, your Constitution doesn't say anything about it. That's not what the Federalist Papers say. The Federalist Papers say really the opposite. The weakest branch, Hamilton said. They won't have a military, like the executive branch, and they won't have the power to tax, like the legislative branch. And so basically, it's the good faith of the other branches and the American people, the basis for the power of the courts. The Chief Justice of the United States, and that's the official title in the Constitution, the Chief Justice of the United States on the Supreme Court, said something extraordinary the other day when he said the court has the final say. Now, again, if you go to law school, you'll hear that. If you're listening to these slip and fall lawyers, some of whom are former federal prosecutors, some of whom are professors, they'll say exactly the same thing. Some of our friends will say exactly the same thing. That's not what the Constitution says. In 1803, the Marbury versus Madison decision, where Chief Justice Marshall seized power that was not granted to the court in the Constitution. I've told you many times about a man who I've had tremendous, I'm trying to find it here, hold on. No, tremendous respect for. There's not a lot. There's people I appreciate, who I like, and so tremendous respect for his intellect, for his scholarship, for his objectivity and honesty. And that was the late Professor Raoul Berger. This man was a genius. He was never a lawyer, by the way, but he was a constitutionalist. He was friends with Bob Bork, among others. But he wasn't much interested in Supreme Court precedent. He was more interested in the Constitution. Each and every framer, what they said during the Constitutional Convention. He was much more interested in the state ratification conventions and the leaders in those various state conventions and what they had to say. And there are writings available, just like Madison's notes. Not all of them, but 9 of the conventions kept pretty good notes. How do I know? Because I read them. There's not another talk show host in America that's read those, but I read them. There's probably not another talk show host in America that read the Anti-Federalist Papers, which are very persuasive, by the way. In no case did anybody say the court would have the final say, let alone lower courts that they weren't even thinking about, because they hadn't been created. In fact, in the Anti-Federalist Papers. One of the most prominent Anti-Federalists turned out to be the governor of New York. He was worried about the courts. He said, I'm very worried about this. There's really no description about the Supreme Court. I mean, outside of very bare details, if you can call them details at all, the kind of power this court's going to have. So it will create its own power base. Again, you'll read about this in my new book. But that said, I'm going to deal with it now. Turned out he was right. So just use common sense, folks. This is a great country because it's a republic. Not because we have lifetime appointed judges, but because it's a republic. It's a whole mosaic. At the top of the mosaic, you have the three branches of government. But below these three branches of the federal government, you have all the state governments. And you have legislatures and governors and judges within the state governments. Then you have townships and cities and villages, and they have their own governments and so forth. It's a mosaic. Now, there's 677 federal district judges. As of today, any single one of these judges, anyone, can rule against this president and put in place a national ban overturning his policy decisions. Anyone. Now, that would have been viewed as absolutely unacceptable to the framers of your Constitution and to the ratifiers in every single state. Why? Because it's tyranny. That's why. You voted in November. You voted for a president of the United States. He gets to make those kinds of decisions without courts looking over his shoulder. The courts have one job, according to Berger, according to them at the time. One job. One job. And that job is to make sure they're traffic cops. The Congress is in its lane, the president's in its lane. It's not to usurp powers and to take them for yourself and substitute your decisions for them. Under no definition is that a Republican form of government. None. Under no definition is that a constitutional system. None. None. My first book was Men in Black about the Supreme Court and the abuses of the judiciary. Look, we've come full circle. My latest book on power gets into this. I'm telling you right now. So here we have this trade court that is ruled because they had, I believe it was 5 petitioners, all with the same ideology, some of them supported by radical libertarians, other of them were business groups. They didn't want the tariffs, and so they said this president doesn't have the power to issue tariffs the way he's issuing tariffs under federal law. That was passed in 1977. I went back and I looked at that act. See what I'll do for you? But I'm also curious on my own. Seriously. Certain emergency powers, but they say they've never been used this way before by a president. Well, the nature of emergency powers is that they're not used very often, are they? No. There's nothing that prevents this. But let's say there is. Or better, more to the point, let's say you think there is. Who gets to decide? Well, ladies and gentlemen, Mr. Producer, is Congress in session? Yes, Congress is in session. We still have a Congress, right? So Congress has the power then, because it wrote the law in the first place, to change the law and say, that's not what we meant. He's taken too much power. And they haven't even taken it up. So why is this trade court saying, you violated this statute, Mr. President, you don't have this power? And the president says, not only do I have the emergency power under the statute, I have those powers, period, as the president of the United States, under Article 2. Now, you may disagree with him. So Congress is the place to resolve it, not some trade court or any court for that matter. Now, to her credit, and I don't normally watch these, This Caroline Levitt, she is a smart young lady. Smart. Because she mentioned that Congress, the play here is in Congress. Congress. If they have a problem with what's happening to their statute, Congress is the one to address it. Not the judiciary, not the trade court. And she's 100% correct. So for those who go online and say, geez, I thought you were a constitutionalist. Gee, I thought you were against tariffs. It's not whether I'm for or against tariffs. We're talking about who gets to make the final decision. Now, if you listen to John Roberts, he does. The problem with his position is it's not based on any constitutional language, any statement from any framer, any statement from any state legislature that ratified the convention. The court grabbed power for itself, and John Roberts is not willing to give it up. But the proper place for this is Congress. Congress is there. Well, they don't have the votes. So what? If they don't have the votes, they don't get to change it. That's the way it works. If the court doesn't have the votes on an issue that belongs in the court, they don't get to change it either. It's not result-oriented. Where does the decision belong? With Congress. Just like I tell you about the treaty clause. Congress. Now, Congress exercises a lot of power it doesn't have. Again, you'll find this in my new book. But Congress exercises a lot of power it doesn't have, too. Congress isn't supposed to be a national legislature that legislates on anything that comes to somebody's mind. You know, we need to fix this. We need a law for this. And we need to... That was never the intent. The state legislatures, that's where the action was. Congress has a lane, too. The president has a lane, too. They all have a lane. When it applies to the federal government, they have a lot of power. But when it comes to society generally, they're not supposed to. Congress is only supposed to pass laws that execute or institute or address matters that are purely federal. And if there's a dispute between a state and federal law, the federal law trumps because there can be an overlap. The line of demarcation may not be that clear. But for instance, nationalizing healthcare. Healthcare is a private matter. It's mostly a state matter. Really, under our Constitution, they don't have the power to do that. Now, don't get me wrong. There's not a court in the world that'll agree with me. Why? Because we're too far gone. I'm just being honest. That's why when America's governor, Ron DeSantis, was on this program earlier this week, he talked about Convention of States. You know that's close to my heart. Mark Meckler and the guys and his wonderful wife, Convention of States. That's the only way we're going to be able to fix this as a fundamental matter, as a constitutional matter. That's it. There's no other way. Because Congress isn't going to fix itself. The Supreme Court's not going to fix itself. But if I were writing my book again, the Liberty Amendments, I would add one more, and it would be with the courts, and I already have one in there with the courts, but I'd add another one. To basically roping the courts off from the sort of things they're doing today. Now, there is an appellate court that stayed, held in place, the tariffs while this matter is litigated, an appeals court, federal appeals court, which was a great move by them, while the matter is being decided through the judicial system. So the tariffs remain in place. The ultimate judicial decision, of course, we don't have yet. This is a time when we need serious men and women on the Supreme Court, and I fear we only have about 4.